Welcome to the Deep Dive. Today we're taking a deep breath and a close look at two massive economies.
California and Illinois.
Exactly. They're both going through these simultaneous and really dramatic regulatory overhauls.
And we're not talking about minor tweaks here.
No, not at all. These are sweeping new labor laws, and most of them hit the books on January 1st, 2026. They will fundamentally change the cost and the risk of employing people in these states.
That's absolutely right. And our job today is pretty simple. We're going to ditch the dense legal boilerplate and figure out what you actually need to do when these laws hit.
Because for any multi-state organization, this is more than just an HR headache.
Oh, it's a guaranteed increase to the cost of every single salary.
Yeah.
And it introduces potential for, well, catastrophic liability if you don't get compliance right.
Okay, let's unpack this. The top line summary is pretty stark. Both states are aggressively expanding employee protections.
They're focusing on radical pay transparency, strict non-discrimination mandates, and really locking down worker compensation rights.
So every employer handbook, every severance agreement,
Every payroll system.
yeah.
It all needs an immediate audit.
We've identified two main vectors of change. First, on the West Coast, California is escalating its minimum wage and putting strict new limits on employment contracts.
Specifically banning those popular stay or pay reimbursement clauses. We'll get into that.
And then meanwhile, in the Midwest, Illinois is focusing more on legal liability.
Yeah, they're expanding the Workplace Transparency Act, the WTA, and hiking civil penalties for labor violations to levels that are, frankly, staggering.
Let's start where the financial pain is most acute. California.
All right, the California compliance crunch. The financial impact is unavoidable, starting with the basics, wages.
The statewide minimum wage is climbing to $16.90 per hour.
And this is where that cascade effect you mentioned kicks in.
Right, that $16.90 hourly minimum triggers an automatic corresponding increase in the cost of employing exempt workers.
What's your salaried managers? Exactly. The minimum annual salary threshold for an employee to maintain that exempt status now has to rise to at least $70,304.
Okay, hold on. Let's make sure everyone gets the implication there. If you have a manager making, say, 70 grand, and they're just $304 under that new threshold,
They're suddenly no longer exempt?
and you have to pay them overtime, that small salary gap could suddenly become a massive six-figure overtime liability if you don't catch it.
Precisely. The cost of labor isn't just the salary, it's the regulatory cost of compliance. But here's where it gets really complex,
Specialized wage increases?
particularly in the huge California healthcare sector. They didn't just pick one number, they created a labyrinth.
It sounds less like a regulation and more like a set of custom tariffs.
It really is. For the period from July 1st, 2025 through June 30, 2026, the minimum wage for healthcare employees varies wildly. It ranges from a lower tier of $18.63 an hour, that's for specific rural facilities, or ones with a high governmental payer mix, all the way up to $24 an hour.
And who does that $24 rate hit?
That hits your large facilities, integrated health systems, dialysis clinics, and facilities in the state's largest counties. Honestly, managing payroll in California feels less like accounting now and more like solving a Sudoku puzzle every 2 weeks.
And beyond the wage cost, California is now dramatically restricting what employers can demand from workers when they leave. That's AB 692.
Yeah, well, standard practice is now banned.
Things like making an employee repay training costs or clawing back a signing bonus if they quit early. Those stay or pay clauses.
All gone. And that's a huge liability swing. Employers are now prohibited from requiring workers to reimburse for any of that.
So what's the risk if you still have those clauses in your existing agreements?
The agreements, or at least those provisions, are automatically void. But worse, the employee can seek statutory damages plus their attorney's fees.
So this forces companies to immediately go back and revisit every single offer letter.
Every training contract, every reimbursement policy, everything.
And the enforcement climate is only getting hotter around pay transparency and equity.
The focus is on closing loopholes. First, the definition of pay scale is now narrowed to the actual range the employer reasonably expects to pay upon hire.
Which stops them from posting some artificially wide range just to satisfy the law.
Exactly. And the definition of wages is now broadened to include all non-base compensation bonuses, commissions, equity awards. The whole package has to be transparent.
With the statute of limitations for Equal Pay Act violations now extended to 3 years, what's the total retroactive risk?
The worry is justified. Because of existing rules, that 3-year statute of limitations could allow an employee to recover up to 6 years of back pay.
6 years.
But the truly punitive measure is aimed at preventing intentional wage theft. If a judgment for unpaid wages remains unsatisfied for 180 days after the appeal period ends, employers face civil penalties of up to 3 times the outstanding amount.
3 times?
We're talking triple penalties, on top of the original debt and fees. That compels swift compliance.
That is serious motivation to get your payroll flawless.
It is. And one last thing, for tipped employees. Employers now have to distribute credit card tips no later than the next regular payday. And crucially, they're prohibited from deducting credit card processing fees from those tips.
So the fee burden is now entirely on the employer.
Squarely on the employer.
Okay, so if California's threat is financial pain, let's look at Illinois, where the threat is more about legal exposure.
Right, especially around contract enforceability and these skyrocketing penalty maximums. Starting with the Workplace Transparency Act amendments, which kick in January 1st, 2026.
And these WTA changes are critical for anyone drafting an employment agreement.
They prohibit agreements from restricting an employee's ability to engage in protected concerted activity.
Let's break that down for people who aren't deep in the labor law jargon. What does protected concerted activity mean in a practical sense?
It's the core of collective action, really. It protects 2 or more employees who are acting together to address working conditions, pay, safety, anything like that,
Right.
even if they aren't unionized.
So if a few employees complain to a manager about something, that's protected.
Yes. This amendment ensures that you can't use contract language to silence them or make them waive their right to band together and speak up.
That significantly expands the risk of wrongful termination claims. And speaking of agreements, the rules for confidentiality clauses have changed a lot.
They really have. For a confidentiality provision in a settlement to be enforceable, it now has to be supported by separate consideration.
Meaning you have to pay extra for it.
And you have to specify exactly what dollar amount is being allocated just for that confidentiality clause. You have to break it out. If you don't say, $5,000 is for the silence agreement versus $20,000 for the general severance, that confidentiality clause is unenforceable.
That is a fascinating legal move.
It is. And beyond that, the WTA now bans using non-Illinois choice of law provisions or out-of-state venue requirements for Illinois residents.
So you can't force an employee to sue you in Delaware.
Exactly. They are protecting their residents, making sure any dispute happens on their home turf.
Now, when we look at this spike in the Illinois Human Rights Act penalties, what is the single biggest behavioral change HR teams need to adopt right now?
Mitigation has to focus on speed and prevention because the penalties are now catastrophic.
Yep.
The IHRA maximum civil penalties are up substantially. We're looking at $16,000 for a first violation,
16?
$42,500 for a second violation within 5 years, and a staggering $70,000 for 2 or more within 7 years.
Wow.
That's a powerful incentive to investigate internal complaints quickly and thoroughly before they escalate to the state.
And beyond the legal penalties, Illinois is also layering on new leave entitlements.
It is. A key one is the Family NICU Leave Act, effective June 1st, 2026.
NICU for newborns in intensive care.
Yes, it creates new job-protected unpaid leave for those parents. 10 days for smaller employers. 20 days for larger ones. But the critical detail is that employers cannot force employees to use their paid time off first.
So it's dedicated leave.
It's mandatory and dedicated. It provides crucial flexibility.
What are the other key new benefits?
A few mandated payments. Employers have to compensate employees for reasonable lactation breaks for up to a year postpartum. For larger companies, they have to provide up to 8 hours of paid leave a month for military funeral honors detail. And organ donation leave now covers part-time employees, too.
So Illinois is really using legislative muscle to build out this safety net of guaranteed benefits.
They are. And wrapping up the financial changes in Illinois, we have a massive shift in hospitality, similar to what we saw in California.
The tip credit.
It's a full phase out of the tip credit allowance. On or after July 1st, 2026, employers have to pay the full minimum wage, regardless of tips. It's a fundamental restructuring of their payroll models.
And just like California, no deducting credit card fees from tips.
Correct. The employer absorbs that cost.
Now let's shift our lens a bit. Let's connect these high-cost labor laws to a specific high-growth sector that's facing dual regulatory pressure. Transportation network companies, TNCs.
Your rideshare platforms. This is where economics and policy collide, And it creates these really fascinating unintended consequences.
Because TNCs are being squeezed from two sides, right?
Exactly. Cities want to control congestion, usually with charges or taxes, and labor advocates demand driver welfare, typically through minimum wage floors.
And your analysis shows these two things interfere with each other.
They do, in surprising ways,
Right.
often canceling out the desired effect.
Okay, let's use the San Francisco case study to make this real. When a driver wage floor is present, so the driver's income is fixed, what happens when the city imposes a congestion tax, say $2 a trip?
Economic modeling shows the tax burden falls overwhelmingly on the platform.
Not the passenger or the driver.
That's right. Because the wage floor fixes the driver's income, the tax primarily reduces the platform's profit. In the simulation, by nearly 60%. The platform just absorbs the hit.
But here's the kicker, right? The unexpected regulatory break.
This is it. The fixed driver wage also limits the charge's original goal, congestion mitigation.
Ow.
The wage floor limits the reduction in the number of TNC drivers, so the tax doesn't curb traffic as effectively unless you set the charge prohibitively high.
So the rule that protects the driver, the minimum wage, inadvertently protects traffic congestion by keeping driver supplies steady, which defeats the whole purpose of the congestion charge.
Precisely. Which raises the question,
Yeah.
Is there a better way to do this, an economically superior way to regulate TNCs that doesn't create this contradiction?
And there is.
Yes. The key insight is contrasting time-based versus trip-based charges. A charge per vehicle operating hour is what economists call Pareto superior.
Okay, what does Pareto superior mean?
It just means it creates a win-win scenario. At least one party is better off and no one is worse off.
And why is a charge based on time so much better?
The time-based charge penalizes idle vehicle hours. It makes empty cruising expensive.
Ah,
So it directly incentivizes the TNC platform to change its core behavior, to increase vehicle occupancy. They have to get more riders per hour to make it work.
which cuts down on all those empty cars driving around.
And this efficiency gain creates a better outcome for almost everyone. The platform earns a higher profit, passengers see a lower overall travel cost, and the city actually collects significantly higher tax revenue. It shifts the whole game from maximizing trips to maximizing efficiency.
We've covered a lot of ground that hits the operating margins in these two huge states. Time for a segment where we put on our trading hats.
And remember, this is not financial advice. Think of it as a thought experiment on market risk.
Absolutely.
Okay, so given the hyper-complexity, the tiered wages, the elimination of the tip credit, and that potentially catastrophic triple penalty liability in California, compliance is now a massive, non-negotiable cost center. So our outrageous but plausible trade idea focuses on capitalizing on that.
Yeah.
We call it compliance arbitrage.
Okay, lay out the pair trade.
We would implement a long-short pair trade. We would short publicly traded multi-state hospitality and gig economy firms.
The ones with heavy reliance on variable minimum wage labor in Illinois and California.
Exactly. Those companies are about to absorb guaranteed labor cost increases and massive liability risk starting in 2026. Simultaneously, you go long on regional payroll compliance and specialized HR software vendors.
The ones who help companies navigate all this.
The vendors that specialize in managing the hyper-complex, tiered, constantly updating regulatory requirements specific to these two states. We're basically capitalizing on the mandated increase in compliance spending that's fueled directly by regulatory fear.
That is an excellent synthesis. The core takeaway here seems clear. The 2026 labor environment in California and Illinois demands an immediate forensic review of everything.
All agreements, all payroll systems, all liability modeling.
The small print matters now more than ever. Whether it's that tiered minimum wage in California healthcare or the difference between a time-based and trip-based TNC tax, ignoring the details is no longer an option.
And that leads to a final provocative thought for you to consider.
Okay.
Given that economic models consistently show the tax burden overwhelmingly falls on TNC platforms when minimum wages are applied, what regulatory incentive remains for these platforms to innovate on congestion relief? If nearly all the resulting tax revenue is captured by the city and driver supply is fixed by the minimum wage,
If the platform can't benefit from the congestion reduction,
why bother trying to fix traffic?
something to mull over as you recalibrate your risk models. Thank you for joining the Deep Dive. We'll see you next time.